So the New York part of the Boy Scouts is in violation of the national policy. If there's litigation, would it be brought by the national organization trying to stop the employment of this 18-year-old, or are you all planning to file litigation to basically clear his way to be employed?
It's hard to see what litigation would happen now. When this started some months ago, one of the issues was whether we were going to have to bring litigation in order to make it possible for him to be hired. He's now been hired. He's been registered as an adult member of the Boy Scouts. That's been done both at the New York Council level and at the national level. And so I don't think litigation is going to be necessary to get him hired. And the New York Council has been pretty clear that they intend to continue to hire him. I think it's very hard to see how the National Boy Scouts organization would bring litigation against the New York Council. The New York Council is simply acting in accord with New York law that requires a non-discriminatory policy in terms of employment. So I think litigation in this particular case is not likely.
So, David, so what do you think then is the, we've discussed this case a little bit before between the two of us. Right. What do you think the national implications of this are beyond the Scouts? What's the why is this significant, whether it goes to court or not?
Every civil rights struggle has two phases, and those two phases go on in parallel to some extent. But one phase is trying to eliminate government-sponsored litigation, government-sponsored discrimination, like school desegregation in the racial area, or like the discrimination of states that barred gay couples and lesbian couples from marrying. And so one phase of every civil rights struggle is to stop government-sponsored discrimination. Another phase is to try to make society, in terms of employment, housing, public accommodations, less discriminatory. You're never able to change everybody's hearts and minds, but what you can do is change the way commerce operates so that it's fair and people have an equal opportunity to be employed, to get fair housing, to eat at lunch counters. The second phase, which goes on at the very same time that you're fighting government discrimination, you're fighting commercial discrimination. But this second phase of ending commercial discrimination is really something that goes on long after you've eliminated the government discrimination. That was true in the racial area, and it's true in the gay rights area.
David, a few years ago, the Scouts changed the rules to allow Scouts themselves who are gay to be in the Scouts. This would be an adult employee. Beyond the symbolism of Scouts in American culture and American life, is there any legal precedent or a more general threshold being crossed by this move?
I think there is. Obviously, as you say, the Boy Scouts is a great American institution. And I think that making sure that scouting is non-discriminatory, that scouting is consistent with American values, is very important in itself. But in addition, I think it is a step in the direction of making our whole society fairer, more equal. Because one of the things it says is that if the Boy Scouts can't discriminate in employment, then neither can Macy's, neither can the local delicatessen, that when you're engaged in commerce, you've got to abide by the standards of the community. And certainly the standards of the community in New York is that we don't discriminate against people based on race, gender, sexual orientation, religion, or anything else like that.
David, I want to ask you about the news we've seen this week in both Indiana and Arkansas, where there have been a lot of attention on these religious liberty statutes being passed, fights over whether there can be some kind of a provision added to them, as was just done, we think, in Indiana. It's not yet been signed by the governor, but they seem to have found a compromise that sort of creates, well, has gay Americans kind of carved out as a protected class with respect to this law, without doing the more general thing of passing an anti-discrimination statute that would cover all of employment statewide, as is the case in about 20 states or so. Tell me, what's the takeaway from this suddenly coming out of nowhere and becoming the center of our attention over these last few days? What does this tell us about the state of affairs in terms of these issues?
I think one of the things it tells you is that the American people are ready to end this kind of discrimination. I think if you find in a state like Indiana a recognition, overwhelming recognition, that gay and lesbian citizens are part of a protected class that's historically been discriminated against, and this discrimination has to end, I think that's an important, powerful step. Now, as you say, it's only half a step. We need to get all the way there. But I think that we need to recognize the importance of taking the step that has been taken and the encouragement that it ought to give that we can take the second step and the remaining steps so that we end this discrimination completely. But that has to be the goal. That's where this country is going. That's where our young people already are. So I think important step, but a half measure.
David, you're a litigator, not a lobbyist, but as an American and as someone who's working hard to expand gay rights, are you indifferent as to whether you make gains in the judicial branch versus the legislative branch, or do you think it would be better for gains to happen with the legislative branch?
I think either way. I think that both the legislature and the judiciary have a responsibility for fulfilling the constitutional promise that we've made to all citizens of equality and fairness. I think that it was important to have legislative gains in terms of marriage equality. I think those paved the way for judicial gains, and then I think the judicial gains paved the way for more legislative gains. So I think those two things are reinforcing, as it was in the battle for racial civil rights. You had Brown against Board of Education, and then you had the 1964 Civil Rights Act. So I think it's important that both the legislatures and the courts focus on expanding the role of equality and ending discrimination. And I think that's exactly what happened in the racial area, and I think that is now exactly what's happening in the area of LGBT rights.
David, I know you believe that on the basis of tea leaf reading and things that are even more substantive than that after the court rules on the gay marriage case that it's looking at this spring, that by the time we get to early summer, gay marriage will be the law of the land in all 50 United States. I'm curious as to how long you think it will be before there is a federal law that bans employment discrimination on the basis of sexual orientation. How far down the road do you think that is? Because that's one of the weird gaping holes right now, that we don't have such a law on the books now.
I think that's exactly right. Now, it took about 10 years from Brown against Board of Education to the 1964 Civil Rights Act. I don't think it'll take that long. I think you already see in some of the legislative initiatives in the Congress a recognition by people in the Congress, in the Senate and the House, Republicans and Democrats, that it's time for this country to move away from its discriminatory patterns against gay and lesbian rights, just as the country has moved away in the racial area. So I think you're going to see it. I think it's going to be a couple of years.